It's really important these employees not only get back on the payroll, but also that they get back to work, because these are civil servants who are proud of the work they do. And what the administration did was they cut off all these essential services.
Rushab Sanghvi, General Counsel of the American Federation of Government Employees, AFGE. Rushab, welcome to the Valley Labor Report.
Hi, thank you for having me, Jacob.
Really appreciate you taking the time. I know that you're very, very busy as General Counsel for the largest federal employees union in the country. You got a lot of court cases right now, and you're doing a really good job, it seems like. You are defeating the Trump administration in court. Obviously, it's all going to hinge on what the Supreme Court ends up doing, but we'll get to that in a moment. And I wanted to just jump right into it and go to, probably the most consequential case, or the most consequential cases in my mind, are the ones dealing with probationary employees, the mass terminations of probationary employees. And AFGE and other unions and other plaintiffs have been winning and getting orders to reinstate these illegally terminated probationary employees. And, I'm regularly asked questions like, why can't the president just fire whoever he wants? He's the president. He's the boss. Why can't he do this? Why can't he do this? And so can you explain, even to help me and also to help the audience, what the statutory basis for these lawsuits specifically are, and why have you been successful?
Okay, yeah, of course, Jacob. First, thank you so much. I think while we are doing a good job with our partners, and we have so many partners we value so much, like AFGE and other unions, as well as some other, law firms and others, I did want to just really highlight, I say this whenever people ask me to talk about litigation, right? The courts are not always our friends. We're going to do as much as we can in the courts. But at the end of the day, it's people power. It's the power of our members organizing, and our members, on the streets, protesting, going to the Hill. That's what's really going to save us from the worst, right? And so, we hope as lawyers, we're doing our best to give you the power to keep fighting on the ground. All right, that little piece aside, right? In terms of the probationary employee cases, I think you're right to ask the broader question, right? And this is something that a lot of people talk about is, hey, the president is the executive. He's the boss of the boss of the boss of the boss of the employees, right? Why can't he direct their terminations? And I think a good place to start is, what the Trump administration's argument is, right? The Trump administration's argument is that he can do that. And they haven't gone too deep in all of the cases on court in this sort of the stark argument. But essentially, they're saying, hey, the president has the authority under Article 2 of the Constitution, which is the part of the Constitution that talks about executive power to manage the federal workforce, right? But the key mistake there, and what the courts have been finding in our favor, and what historically is the case, is there's something before Article 2, and that's what the Trump administration kind of through sleight of hand, through sort of ignorance, or not ignorance, through willful ignorance, tries to ignore, is there's Article 1 of the Constitution. There was a reason the framers has had Article 1 come before Article 2. And, I know not everyone, remembers the Constitution at the back of their hand, but Article 1 is the powers of Congress, right? The powers of the legislative branch. And if you go all the way back to the founders, right? Why was this country founded? It was founded, in part to push back against a monarch, a king. And so the founders were very clear that Congress, came first. Congress was sort of the people's power, and that came first. And so when Congress creates these agencies that employ federal employees, and when Congress provides money, because Congress is the sole holder of the power of the purse, they say, right, of the funds through appropriation statutes, Congress directs the president, hey, to spend money in certain ways. There's a lot of discretion there, but he has to spend money in certain ways, and some of that is providing services through employees. And then Congress also created protections for employees. And the reason for these protections is very important, and it was even way back when people understood the importance of having these protections because the people we don't want a spoil system, right? We don't want a system where the president can fire everyone and put on all his lackeys and then therefore sort of imperil democracy. And so Congress made it clear that there are protections for these employees, and the courts have found, yes, Congress vested in and there's sort of nuances to the argument, but broadly speaking, the courts have found that, yes, Congress created these agencies, Congress provided protections to these employees. The president cannot at will just sort of ignore what Congress has done here. He cannot, dismantle agencies where Congress has said that they need to exist, where Congress has appropriated funds for them. In the case of the probationary employees, right, what happened there was the president, through the Office of Personnel Management, decided, hey, we're just going to decide and tell all these agencies to fire all these people, irrespective of their performance, irrespective of the rules. And the court found, right, there's no precedent, there's no legal basis for that. When Congress created all these different agencies, Congress said it was the heads of those agencies that had the ability to do that. And then, both Congress and prior administrations put in rules for how that needed to be done. So that's the sort of the big picture there on why the president can't just unilaterally fire people. And I think it's important to remember, right, the president is not a king, and that's one of the foundations of our democracy.
Absolutely. And I think that kind of historical stuff that you said at the beginning is really important to remember, that Article 1 comes before Article 2 precisely because the founders were trying to get away from a king, from a all-powerful sort of executive, and because Congress, like you said, created a lot of these civil service protections. The president cannot just get rid of them. And the president could go to Congress and ask for Congress to get rid of them. I mean, we didn't always have these civil service protections. I mean, we created civil service protections because we used to have a spoils system, and the American people were like, this kind of sucks, having a completely incompetent federal government that can't do anything because it's just people who are politically loyal to the president. We don't like that. We want to have actual professionals in these jobs within the federal government. And so Congress passed civil service protections multiple times. And some of those included that, yes, the secretaries of the agencies, like you said, have the ability to hire and fire. And also that when you hire and fire, particularly in this case, when you fire, you have to have cause, even when it's a probationary employee. And one of the things that your argument hinges on, I believe I'm remembering correctly, is that the cause in this case was a lie. Right? All of these probationary employees were told that, your performance is not adequate enough, and that was clearly not the case. Some of these had literally in the weeks prior been given glowing performance reviews, and it was all a form letter. And so there's absolutely zero evidence that there genuinely was a real effort to try to assess the performance of these probationary employees. And so on multiple fronts, this was an illegal firing of the probationary employees, is your argument, and I think I accept it. But could you explain, one of the things that Judge Alsop said in the case was that, the president can fire people. Can you explain, I don't want that like there exists authority to go through proper channels and do reductions in force and stuff like that. And as a union, we are always going to try to do everything that we can to protect our members. But there are proper ways to do this that would have been much more difficult for you to challenge, right?
Yes. And so Judge Alsop he's a very good lawyer, a very careful judge, a very smart man. And, in his decision, one of the things he wanted to make clear is that he wasn't saying the president doesn't have the ability to terminate these people that were terminated. And I think part of that is, and I don't know what his thought process was, but I think part of it is there's a lot of disinformation out there, specifically from the administration, trying to say, hey, these judges, these unions, they're saying that the president doesn't have power. We're trying to take away his power to do things that he has. And so I think, one thing is, and we've been clear too, right, in our cases, and this is what Judge Alsop was saying, is that the president does have a way to engage in mass terminations or reorganizations of agencies. But there's a process he has to follow, the reduction in force process, and that process, is not what was at issue at this case, right? We weren't, that to the extent that happens and it's happening elsewhere, we will litigate it, if it's done improperly. But there is a proper way to do this, and this, here the administration was trying to bypass that. They were, flouting the laws that essentially that they need to follow in order to do terminations. And I think that was one thing the judge was very clear about, saying, hey, there is a way to do this, but here they're not doing it. And then he highlighted the fact that the performance, like you said, was essentially a sham or a lie, right, to try and get around these laws.
And so Alsop said you have to rehire these probationary employees. You fired them illegally. There was a second judge that issued a similar ruling at other agencies. And I'm now seeing a trickle of articles about employees being rehired, but it does seem to be a trickle. Can you talk to us about, and I know you're in the legal department, so maybe this isn't your purview exactly, but what kind of visibility do you have on the logistics of these employees actually being brought back into the agencies?
Yeah, so I mean, there was a compliance report that the government had to file in both of these cases. We also, as the union representing more federal employees than any other union, we are hearing from our employees. I think one of the hard things is the government is not being as clear as we'd like on it, and so we are hearing of probationary employees being rehired in many instances, throughout the federal government, at those agencies covered by the case in Maryland and at those agencies covered by our case. It's trickling in. It's not as clear as we'd like to see. One real big distinction, though, is, and we're trying to track down more information on this, as is the judge. He actually sent out rulings on the court not rulings, letters on the court docket asking the government for more information. But one piece of information that's really important is how they're rehiring these people. Because in Judge Alsop's decision in particular, right, he indicated, right, the reason he's granting this relief, part of the relief he's granting is that services that were affected by these mass terminations, and some of the examples we provided are impact to the crisis hotline for veterans, the closure of national parks, or the limitation of access to those parks. So Judge Alsop was saying, hey, the remedy is you need to put people back in their positions to actually start providing these services again. And what we've been seeing is the government reinstating employees, but putting them immediately on administrative leave. So essentially saying to the park ranger or the person in the Forest Service, here, you're back to work, but really you're not back to work. You're just on leave while we figure this out. And so there's a lot of confusion around that. And it's really important, that these employees not only get back on the payroll, which is important in and of itself, but also that they get back to work, because they these are civil servants who are proud of the work they do. And, one of the big issues here is what the administration did was they cut off all these essential services by, this mass firing.
Hey, 5 seconds. Just wanted to say that this is only possible because of our donors. If you want to see more of this, then consider donating yourself at tvlr.fm/donate.
One of the things that has been, kind of... It's really big, I think, in the lives of federal workers, but there's not been as much news around it. I think in part because the executive does have some level of authority over this, and that's about telework. What the executive order on telework amounts to is a significant, degradation in working conditions for federal employees. It amounts to a pay cut. It amounts to a less efficient federal service. All sorts of reasons. It's a kind of a silly thing to do, but I've seen in my area agencies really kind of steamrolling over the union in the bargaining process and not really allowing for adequate time to bargain over implementation, not trying to work with us on some give and takes. I know the bargaining committee at one agency that I'm familiar with requested at least 3 days of a week of commute time to be allowed to count towards your tour of duty, right? And I think that's a reasonable sort of compromise. If I was teleworking 3 days a week, you're going to make me come into the office 5 days a week. Well, give me 2 or 3 days a week where the commute counts towards my time on the clock. And management just laughed at them, right? And so do we have any sort of nationwide case in the works about failure to bargain from the agencies over return to office?
So, and I think you hit on a point, right, with the discretion, right? So, unfortunately, the telework issue is a agency specific, contract specific issue. So most of the the telework benefits that we our different units at different agencies have are based on contractual provisions or telework agreements negotiated with the agencies. So in some agencies, for instance, or in some positions, right, there was no or limited telework. Some contracts had sort of a lot more discretion in how much change the administration can do with telework. Some others didn't, and so there's really no nationwide case, so to speak, with that at this point. With respect to the executive orders too, right? It was also sort of a piecemeal thing, right? First, the president issued this memorandum, then he issued an executive order, then OPM issued guidance. So it's a little kind of, it's been done in a different way at different agencies. But what we've been doing at our office is we've been helping all of our affiliates with demands to bargain and grievances. And so there are some larger agencies and affiliates that had a stronger provisions in their agreement in which we've filed sort of national grievances or helped them with national grievances that we'll be litigating in the coming weeks.
Great. Well, looking forward to seeing that. Let's go to another case, privacy. We've seen some level of success as far as keeping Doge out of, the private data of employees of agencies and of the citizens. And, one of the things that I've heard in response to that is like, oh, well, Elon Musk doesn't want your social security number. He's the richest man of the world. Why would he care about having that? He's not going to steal your social security check. And, I will just say that one of the Doge bros was literally fired from the previous company that he worked at before Tesla for revealing secrets of the company to a competitor. So, there is some level of that just base concern, but what is the case built on, right? What is the case built on when you're going and trying to keep Doge out of, Treasury Department data and stuff like this? And what is your response to folks like that?
Yeah, so there's many things. I think one thing we should note, is AFGE and in a lot of these privacy cases, and in all of our cases, but I think the privacy cases are one of the ones where, it's best highlighted is our leadership, our president, Everett Kelly, and our National Executive Council, and the same with, AFSCME's leadership. In a lot of these cases, we're fighting for our employees, but we're actually putting ourselves out there because we believe as a union that not only is this important for our members and those we represent, but this is a fundamental issue for democracy. And we know that our members support fighting the administration on everything, even if it's a small issue for our members. If it's a big issue for democracy, we want to be out there. And these privacy cases are in part related to that. And then to answer your question about Elon Musk doesn't need your social security number. He's not going to, hack your account and buy some shoes on REI. And I use that example because that happened to my wife the other day. It's not about money, essentially. It's about power, right? I mean, it's about power and accumulating power, and money is a route to power. And you've seen how much data Facebook and others hoard, right? And so this is about taking that information to accumulate power to sort of harm other areas in our government, in our democracy. And so, this is a much bigger issue than just potentially Elon Musk using it to accumulate funds, right? He's
Right.
using it to help prop up an autocracy. But in terms of the basis for these cases, most of these cases are based on the Privacy Act, and other sort of statutory provisions with respect to agencies and the access to data. Because what's happening is Doge is putting these people in, and they don't have a need to know. They're not actually functioning um, in a way in which Congress intended them to function, right? Congress didn't create like the Treasury Department and say, hey, Doge is going to be accessing it, right? It's the people in the Treasury who should be, right? And so a lot of this is related to that. It's also related to the Privacy Act protects who gets access to this information. And, in the initial stages of this, right, it was quite ludicrous, right? There were people, and, you've heard the stories, right? Like 19-year-olds who were hired by Doge, who just went down to the Treasury and were like, give us the keys to all the information. They had no
Right.
connection to the agency, no need for that data. And so we've been very successful in getting courts to limit that access in at different agencies. Not only the Treasury, we have a big case with OPM as well.
Last case, and then we'll wrap up with a bigger picture question. You mentioned that you just filed a lawsuit to stop the dismantling of the Voice of America. What is that case around?
Yes, so we with number of different partners, and there's a number of journalists at the Voice of America. There's a number of free press nonprofits that rely on the Voice of America around the world who are plaintiffs in this case too. But AFSCME, AFGE, and APSA, the three unions, we wanted to put this together and go as hard and quickly as we can. So just as background, you may have heard in the news last week, essentially the government is shutting down the Voice of America, which people rely on all over the world. They've taken all the employees on administrative leave. They shut down broadcasting, and they're trying to silence journalists because they view these journalists as opposed to the Trump agenda, and they're using these excuses in terms of waste, fraud, and abuse, which are not true. But so we filed this case with our partners on many different grounds. It's a First Amendment case because we believe that the administration is retaliating against these journalists, many of who are our members, for accurate reporting. It's also a statutory case on the basis of what I talked about before, where Congress it's clear. Like I was reading the appropriations bills the other day. Congress said, "Hey, this amount of money goes to these functions." Congress also made very clear when it created Voice America that there's a firewall between the administration, any administration, and the journalism, because they wanted the journalism to be independent. And so there are these congressional or sort of separation of powers issues as well. We think it'll be a very powerful case, and it's a very important case because it's in the line of cases of where the administration is trying to accumulate power and is trying to silence. They're trying to silence not only the unions, they're trying to silence any voices of opposition. And so we're very hopeful that this will be successful, and it'll get our members and members of the public even more motivated and activated to fight this administration.
And so to wrap up, obviously a lot of this is going to be going to the Supreme Court, right? And it's all going to hinge on what the Supreme Court does. And I think that you have laid out very convincingly the case that you're making and winning before some of these lower courts. And it seems to me very clear just as a textualist, if you just look at the text of the laws and the civil service protections that have been approved by Congress, that, Trump doesn't have a lot of the powers that he's trying to assert. But in many ways, this is a Trump Supreme Court, even though the letter of the law is clear. And so what are your thoughts about your chances at the Supreme Court when these go through the appeals process and head up to be decided on there?
I have hope. And I believe that again, every case is gonna be there's going to be a different analysis. There's going to be it's going to be viewed by the court differently. But I have hope, and I think the Supreme Court has shown, especially Justice Roberts and others have shown some courage, and some, have stood by the law. Not always, right? But again, I have hope. I think some of the examples we had have seen are, and for instance, these were very technical cases, but there was the Dellinger case, which, we ended up losing, or the OSC special counsel lost at the Court of Appeals. But initially, the administration asked the Supreme Court to not only to basically go over years of precedent and say, hey, we're gonna put a stay on this TRO, and that was something that would have been outside or extraordinary, and the court declined to do that. Similar, we had this a USAID case that we're not a part of, but it involved grantees, and the Supreme Court allowed the lower court's decision to stay in place. How that case ends up eventually, on the merits when it gets to the Supreme Court, it's another question. But I think the Supreme Court has shown shown that for now, at least, there's some restraint there, in terms of honoring the law, right? And so I am hopeful. That said, we don't know how this is going to play out, and that's why I always say, right, the courts are not our friends. It's going to be people like you, Jacob, and the rest of the movement who make sure people understand the stories and understand how terrible the consequences could be if we continue to allow the administration to go down this path. So it's going to be, people power that's going to win in the end.
Right. Well, Rushab Sanghvi, General Counsel of the American Federation of Government Employees, the largest federal employee labor union in the United States. Thank you so much for your time. Is there anything else that you'd want to leave us with before we let you go?
No, just thank you all, and just keep speaking up and keep sharing your stories and helping us share our stories. And I think that, I am hopeful that we will prevail.
Absolutely. Rushab Sanghvi, thank you so much for your time. Appreciate it.
Thank you.
AFGE.org/join. If you are a federal employee, you can join the union there. And you very much should, because we got to be able to pay lawyers like Rushab to fight for us in court. Obviously, like he's saying, and it's correct. The courts are ultimately not going to be the end-all, be-all, but they can provide. They're a good defensive tool. So we need to be able to make use of them where we can. You just saw a clip from the Valley Labor Report. We are live every Saturday morning from 9:30 a.m. till 12:30 p.m. And we pride ourselves on keeping all of our content free to everybody so that we can talk to as many working folks as possible. If you support the work that we're doing, you think that it's important, you think that it's good, then consider making a monthly contribution to the project, and you can do that on our website, tvlr.fg.